A federal judge has delivered a ruling that strikes at the core of constitutional rights and immigration policy. Mahmoud Khalil, a Columbia University graduate and lawful U.S. resident, found himself in the crosshairs of an administration determined to silence dissent. His arrest wasn't because of any criminal act. It was because of what he stood for, what he believed, and what he said. On May 28, U.S. District Judge Michael Farbiarz issued a landmark 106-page opinion, calling into question the very foundation upon which Khalil's detention was justified. The Trump administration had argued that Khalil's presence threatened U.S. foreign policy interests. Not because of espionage, not because of violence, but because of his pro-Palestinian advocacy. He was arrested in broad daylight, in the lobby of his Manhattan student apartment. No warning, no charge, no crime. Born in Syria to Palestinian parents, Khalil stood as a spokesperson and negotiator for peaceful protesters at Columbia University. He didn't incite violence. He called for justice. The government didn't see a peaceful protester. They saw a threat. They pointed to a little-known section of the Immigration and Nationality Act, a section so vague that Judge Farbiarz wrote it could not pass constitutional muster. Unconstitutionally vague. Those were the judge's words. Vague enough to be abused. Vague enough to detain someone not for what they did, but for what they believe. This is the United States. And here, beliefs are not crimes. The Trump administration's attempt to conflate Palestinian advocacy with terrorism was not just dangerous, it was deliberate. It was a message: dissent will be punished. But Judge Farbiarz pushed back. He didn't just rule against the deportation effort, he dismantled its legal foundation. He made it clear that belief, protest, and political expression are not grounds for deportation. He affirmed that constitutional protections don't vanish with a visa. Khalil, a green card holder and husband to a U.S. citizen, still remains in detention in Louisiana. His release was not granted, at least not yet. The government claimed inaccuracies in his residency paperwork. The judge said those allegations require closer inspection. That part remains unresolved. But the larger picture is clear. You cannot deport someone because their views challenge your policies. You cannot jail someone because their advocacy makes you uncomfortable. This ruling doesn't just affect Mahmoud Khalil. It sets a precedent for every immigrant who dares to speak up. It reminds us all that the Constitution protects people, not just citizens. It protects voices, even when they speak hard truths. Especially when they speak hard truths. This case is about more than immigration. It's about freedom. It's about what kind of country we are, and what kind of country we aspire to be. In times of political division, in moments of unrest, it becomes easy to criminalize the other. But the courts exist to draw a line. And Judge Farbiarz drew that line. He stood for due process. He stood for clarity in law. He stood for the First Amendment. Mahmoud Khalil may still be behind bars. But this ruling is a win for the principles he represents. The battle isn't over. The legal system moves slowly. But momentum is shifting. The federal court has signaled that weaponizing immigration law for political ends will not go unchallenged. The era of guilt by association must end. A person's birthplace does not make them suspect. A person's political stance does not make them criminal. A person's protest does not make them terrorist. These truths must be defended, repeated, upheld. This ruling reminds us, the Constitution is not a selective document. It doesn't shrink when it's inconvenient. It doesn't retreat when it's politically risky. It endures. And for Mahmoud Khalil, it may yet be the force that sets him free.